Breaking news in the case of 22-year-old Gabby Petito. You remember, strangled to death by her 23-year-old fiance, Brian Laundrie. Weeks later, he committed suicide. Gabby's parents sued the Laundries for emotional stress in connection with their daughter's death, meaning that the Laundries knew what he did at a minimum and let the Petitos suffer in the unknown. Today in court, what's being called the burn after reading letter that Brian Laundrie's mother wrote to her son was admitted as relevant to the civil suit. The contents of the note expressed the mother's unconditional love for her son, but how becomes the issue, or one issue. It included references to helping her son dispose of a body, if need be. That's what's getting all the news. Attorneys for Brian Laundrie's parents claim, despite the incriminating contents of the letter, it was written long before the murder. Let's bring in defense attorney Mark Geragos and Florida prosecutor Dave Aronberg. Dave, why is this confession more than comedy?
Yeah, good to be with you, Chris. It's important in the civil case. Remember, these are different rules of evidence. It's looser than in a criminal case. But it's important when you try to show that Brian's parents allegedly knew that Gabby was dead when they released that statement saying, "We hope the search for Miss Petito is successful." And then at the same time, they were ghosting Gabby's parents, ignoring their calls, blocking them on Facebook. And so Gabby's parents are saying, see, you knew that your son killed Gabby, and yet you were putting us on. You were leading us along. You were essentially torturing us mentally, which is the intentional affliction of emotional distress. And it's going to be up to the jury to decide whose side of the story they're going to believe, whether this was a letter pertaining to Brian's conduct in killing Gabby, or whether it had nothing to do with it at all, as Brian's parents are saying.
Mark, I don't dismiss the idea that Brian Laundrie's family may have known more sooner than they let on, or that the rest of us knew. However, I have two problems here. One, you got to show me when she wrote it. She says she wrote it before. The plaintiffs here have the onus of showing that that's not true. The second thing is, I keep seeing it reported, this is why I almost didn't do this tonight, that it was found in a backpack. Dusty, put up a picture of the letter again. That backpack was supposedly underwater for like weeks before it was found. This letter wasn't wet. Nobody said that it was found in some Ziploc bag or something. So, you know, if I don't trust that they say they got it from where they got it, then I need to know more about its relevance. What's your take?
You know, usually when you have something like this and you're making the argument that this is unreliable, usually a judge will either exclude it or do a hearing prior to its admissibility. If he does want to let it come in, they use, or she, they will say it goes to weight, not admissibility. I don't know that that was done here, number one. And number two, I think your point about the timeline is something that they're going to have to struggle with in closing or in the instructions, because there is a real problem when you've got a mother writing to their son. I've always wondered why there isn't some kind, you know, we have all kinds of, we have marital privileges, we have attorney-client privileges. Why aren't there, you know, filial privileges, or why isn't there a maternal privilege, so to speak?
There is in my house. My wife keeps confidences for my kids that I don't want her to all the time. Yeah, but finish your point.
Yeah, well, I'm not going to go there. It's not Friday night. I'd have more fun with you about the paternal privilege. But listen, the interesting thing about this is that a jury is going to hear it. I'm always, you know, a fan of jury verdicts. I don't always agree with them, but they'll fight it out and they'll see. Somebody will make the argument that this thing is concocted or that this thing may not be legit, and then they'll have their ability to cross-examine. The one thing, as Dave mentions, in civil cases, you can sit on your right against self-incrimination, Fifth Amendment, in a criminal case. You can't do that in a civil case. In fact, if you try that, you get all kinds of penalties, and ranging from an inference to terminating sanctions. So somebody may get up and have some splaining to do.
Right. I'm just telling the people at home, you should read the letter. There's plenty of ways out there to get the full contents. There are a lot of metaphors in it. Those two are inconvenient at a minimum. No question about that.
Well, also remember the other interesting thing, Everybody thought he was guilty. So when she's writing
Right.
it, this is not breaking news that everybody thought he'd already done it. So she might have been coming from that space.
Well, but she says she wrote it when they left for the trip, which was before any of this ever happened. But I'm saying she doesn't just say, you know, I'll help you with the bags of a body. She says, if you go to the moon, I'll wait for you to come back. You know, she says there's a lot of metaphors in there. That's all I'm saying. Hey, thank you for watching. Please go to newsnationnow.com, newsnationnow.com, and you can find News Nation on your television provider. And don't forget to click the red subscribe button down below. Then you will get more of News Nation's fact-driven coverage.